Professor Kanjip, did you want to respond to that last point we were talking about? I think there was a hanging Chad there somewhere.
The content moderation issue?
Yes, yes.
Yeah, so I think it's an interesting question. And it does go, as correctly pointed out, to the section, I think it's 3.3, that prohibits a platform from discriminating in the application and enforcement of a terms of service of the covered platforms among similarly situated business.
Having a hard time hearing you. Can you move your microphone? Yeah, thanks.
Is that better?
Yeah, that's better.
Okay.
Thanks.
So it goes back to this section 3 that prohibits discrimination among similarly situated business users. And so what does that actually mean in life? Well, you could imagine, a dating app that only is for, Nazis or, communists or something like that, and a platform didn't want to have it. And the question is, what would be the remedy? I think it was pointed out, they would not have a private right of action. I mean, you would have to find some attorney general or the Department of Justice to take up their cause, which I would find extremely unlikely. I do that in the abstract. It does present this problem, but I think in reality, it's not something that is likely to occur.
Right, right. And if it were to occur, we're talking about a very weird niche market. I mean, one that would not likely amount to a significant percentage of the population ever, one would hope. And so if you ended up in that circumstance, you'd be dealing with something different than where you have politically motivated content moderation decisions that may cut against where roughly half of Americans are excluded from it. Is that part of their point?
Yes, precisely, because there is no private right of action. I mean, you'd have to have the judgment and common sense of elected officials, and I would be very surprised if they would take up that cause.
Right. All right. Back in 2021, Apple, Google, and Amazon, as you mentioned a little while ago, deplatformed Parlor. This, of course, was a popular and quickly growing competitor to Twitter that was favored by many in the sort of libertarian to conservative community. Conservatives have, of course, been lectured for years that if conservatives don't like how a tech platform moderates content, then they should just go build your own, as many of us were told. So the Parlor example, I think, illustrated how shallow and how empty that response would be. Do you agree that Google and Apple ought to be barred from preventing users from installing apps of their choice on their devices?
I think that's a reasonable, targeted remedy. As I pointed out, Google and Apple are only able to skew public discourse because of the market power they enjoy. I think a targeted solution that says, look, you're unusual, you're sui generis, you're the big guys. We all depend upon you. You have general obligations to the institutional values of the United States, and I think that would be a targeted and limited approach that would be effective.
Part of what has left so many of us cynical about what happened with Parlor is the fact that Parlor was, it had hit its sweet spot, it had hit its stride. It was doubling, I don't remember what the stats were, but it was doubling its user base every 6 weeks or something like that. It was growing by leaps and bounds, and all of a sudden in early 2021, out of the clear blue, some tech giants combine together and all decide, as if miraculously, that they're going to shut them down, and they do shut them down. Now, they make decisions eventually that allows Parlor to come back, but by then the party's over. By then, it had lost the vibe, and these things are such that if you cut that off at the wrong time, and you take them essentially offline for a couple of months, it's a death knell, and they've never recovered as a result. Professor Scott Morton, could we have avoided the situation that we're in today if we had just had better enforcement of our antitrust laws over the last 10 or 15 years or so?
Thank you, Senator. I think the answer is not so much enforcement, but the jurisprudence in the courts. When you have rules like Brook Group and jurisprudence like Amex and Trinco, it really sets such a high bar for the plaintiffs that you can have very good enforcers, but they just aren't going to win in the places where the consumer needs them to win.
Do you think if the antitrust law has been weakened by lax enforcement, is that part of your point?
No, I think it's been weakened by a tradition that's very old now from the Chicago School in the 70s that made a lot of assumptions for courts, like markets will self-correct on their own, you should be really afraid to enforce, the predatory pricing doesn't exist, oligopolists can't collude, things that we know to be actually not part of the economic learning that we have and not part of how markets work. But if you make those assumptions, you don't need antitrust enforcement, and courts have been, therefore, dialing it back really quite steadily over the last 40 years.
Professor Francis, how do you respond to that same question?
I agree with, I think, almost everything Professor Scott Morton said. I think, a lot of the criticism that has been leveled at enforcement agencies would better have been leveled at the decisions of the federal courts on some important margins in the last couple decades. But I'll add that I also think part of the problem is that our statutory standards, even though we've been working on them for 130 odd years in the case of the Sherman Act, could really use some clarification, right? So 1890, the Sherman Act gives us restraint of trade and monopolize. Those are still battlegrounds in litigation today. 1914, Clayton Act, substantially lessened competition. The courts, for sure, have been taking, antitrust cases should be hard to win, but they shouldn't be impossible to win. So courts have been unduly receptive to defendant arguments for several decades. But it's not just the courts, it's also the fact that they're looking at statutes that really could be clarified by Congress in some pretty common sense ways that I think would really sharpen antitrust on some very important margins. Monopolization law, merger law in particular.
And doesn't that suggest that a lot of these problems could and should be dealt with most appropriately by through reforms to the way we enforce them, reforms like those suggested in the TEAM Act rather than implementing expansive, untested new regulatory regimes?
I think that antitrust enforcement, not just for a small number of tech companies, but across the economy, is the most important competition policy problem we face right now and an urgent need. And I want to just respond to the idea that ICOA is a kind of fast-track antitrust. It really is not. Antitrust enforcement focuses on the use of market power in ways that harm consumers. When you consider all pro-competitive justifications for a practice, it would be protecting inter-platform competition here, making sure that we weren't suppressing or deterring the emergence of competitors of Google and Facebook and Apple and others. And it rejects the kind of blanket duty to deal that ICOA imposes. So
seems almost anti-antitrust.
That is exactly.
Double negative. It's just a trust at that point.
It turns the trading partners of these platforms, who would be the very businesses best placed to become or to sponsor competitors, into stakeholders in the status quo. And not only is this not antitrust, it's not even accelerated antitrust. If Congress passes this bill, we're going to see a generational landslide of litigation over concepts like critical trading partner, fair and neutral search rankings, preference, part of or intrinsic to a digital project. The mechanism of enforcement is the same as antitrust. We're going to see enforcement actions brought by agencies moving through the federal courts at the same pace as antitrust, but doing less good.
So 133 years later, we're still arguing over things, the meaning of things enacted in 1890. If we enact other language, sure, we're still haggling over it, but we have developed over time a pretty sound understanding of what they mean. If we develop this could be another 130 years of exploratory litigation. It would be really good to fund the private college educations of the children of lawyers everywhere, but could create chaos.
This is going to cost the economy a fortune in compliance costs and attorney fees, even before we get to foregone innovations or failure to protect consumers. I would love to see us take a fraction of that money and use it to support antitrust enforcement.
All right, let's talk about the Open App Markets app for a minute. It, of course, banned dominant app stores from using MFNs. Would this help bring more competition to that space?
I think it could, Senator, and one of the things that I like about it is this promotes inter-platform competition. So the idea is that if you take away the power of an app store with market or monopoly power to say to app developers, hey, don't offer a better price elsewhere, if you take away their ability to do that, then suddenly big app developers can sponsor competition against the app store itself by offering discounts or other preferred terms. So I would support an MFN ban here, as in other markets, with market or monopoly power.
Professor Lewis, would ICOA prevent a company like Amazon from charging different prices to business users on its platform based on a user's size?
Oh, I'm sorry, Ms. Lewis. I'm not a professor, but
I'm sorry.
that's okay.
Today you are.
I'm sorry, could you repeat the question?
Yeah, would ICOA, as you read it, would it prevent a company like Amazon from charging different prices to different business users on its platform based on their size or the volume in which they deal?
So on it, my reading of it is that it would not, but I would want to go back and really do an analysis to look at the statute and confirm that that's accurate.
Do you think it's unfair to charge different businesses different prices based on their size?
So again, I think I would have to give that some more thought because there's no context there. So I would really want to look at the individual facts of the situation before I would make a blanket statement.
Okay. Professor Scott Morton, let's go back to you for a minute. ICOA would require enforcement actions to be brought in federal court. Well, I've got concerns with the breadth of the bill. I view this element as absolutely essential to protecting due process. Would you agree with that?
Yes, that's right.
What in your view, are there things that would be better than this, or is this the right thing to do it?
Well, I think, as I said in my statement, in some ideal future world, we have a regulator who's expert and can use the public interest standard, not just competition, but privacy, security, all these other issues you've been raising. In the absence of that regulator, I'm against the status quo. I think we should try to move forward with a bill like this. I think the possibility of public enforcement rather than private enforcement limits the kinds of cases that are being brought to ones that are meritorious and necessary. And so with luck, you wouldn't get platforms engaging in litigation where it's pretty clear that the instructions in the statute require them to do something.
But you think it would be preferable to have them handled by experts in an enforcement agency, sort of a beefed up panel of Uber experts?
Well, as I said, when we invent technologies, typically in the United States, we also bring a regulator along with them, whether that's trains or pharmaceuticals or airplanes or whatever. And I don't think this technology is any different in that regard. But it usually takes Congress a really long time to regulate dangerous things. I don't know why that is. You probably do. And so in the meanwhile, I think something like this, where we're working through the courts and building off of what we know from the antitrust context, is an excellent first step.
Okay. Thank you.
Very good. Senator Blumenthal.